do this.
Hello, and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery. Today's Doug Austin. It's called Important eDiscovery Case Law Decisions for July 2022. Our faculty experts are, of course, Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the council. This webinar will be recorded and available for your replay at your convenience, as are every month's webinars. Please take a look at the attachments tab for a link to register to August's case law webinar. Keep up with Doug at eDiscovery Today. There's a link there for him. Tom O'Connor's Spicy Techno Gumbo blog, and learn how you can engage with Judge Peck. And then up next on our webinar channel, the Tom and Jeremy Show, Why Use a Nail Gun When I Have This Old Hammer? And I can hear the jokes coming, Doug. You all can download a certificate of attendance from the council after the webinar to use for your continuing ed requirements. So we have Doug Austin, our editor of eDiscovery Today and EDRM partner. Doug has over a decade of experience in the trenches of eDiscovery and posting at least once, and this year, way more than once each day since 2010. Doug earned Reader's Choice Awards from JD Super in eDiscovery and Cyber previously, and he will win again in 2022, we are predicting. And Tom O'Connor, hailing from the wonderfully beautiful city of New Orleans. For over 3 decades, he's stewarded the Gulf Coast Legal Technology Center and has a wonderful YouTube channel for long-form interviews of eDiscovery luminaries. He is a sought-out consultant on some of the largest cases. And the Honorable Judge Andrew Peck retired as a federal magistrate judge in the Southern District of New York after 20 years, but not until he wrote many of the first opinions on eDiscovery generally, search terms, boilerplate objections, 502D orders, and of course, technology-assisted review. He's a graduate of Duke Law School, and now with DLA Piper, he advises on information management, particularly in the eDiscovery context. He also acts as a mediator, arbitrator, and special master. And EDRM is grateful to all 3 of these gentlemen for serving on our EDRM Global Advisory Council. Now, Doug, do we have cases to talk about this month? Did anybody write any opinions?
There were a few opinions. In fact, Mary, in the spirit of Shark Week, we've got so much eDiscovery case law this month. We may need a bigger webinar. We have 6 cases, and they involve disputes regarding search terms geographically limited by email signatures, timing of motions to compel, a third-party subpoena on plaintiff's counsel, who was also a journalist that wrote books about the famed Making a Murderer case, cost shifting to correct production issues, privacy versus relevance for a forensic inspection of China computers, and authentication of social media evidence. And just a reminder, in case you're wondering, we will send a copy out of the slides after the presentation, so you can look for that. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Our lawyers might take a bite out of us if we forgot to mention that.
Is that the first shark?
I promise I'll stop. I will.
No, you won't.
Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 23,800 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case was about claims of monopolizing the markets for aligners and scanners, where the defendant, an international company, included geographic limiters in search strings, such as the example you see in bold there in the first bullet point. An email that hit on any other term in the search string would only be reviewed if it also had one of the geographic limiters in it per that example. The plaintiffs agreed to using geographic limiters on searches, reserving their right to challenge them later because the defendant assured them that its employee email signatures typically contain one or more of the geographic limiters at issue. Yeah, that's the ticket. Once they reviewed that the defendant had produced, however, they asserted that defendant employee emails almost always have either no signature at all or signatures without geographic limiters. The defendants claimed that the use of geographic terms in email signatures was widespread, but acknowledged that it was not universal. After acknowledging the defendant's legitimate reason to limit document review to documents that are likely to be of evidence of conduct in the United States, California Magistrate Judge Thomas Hickson stated, when U.S. employees email each other about conduct that is relevant to this case, there is no reason to expect they would explicitly refer to the U.S. in their emails. That's just not how people write. As a result, the geographic limiters are a random, arbitrary limit on discovery, unrelated to whether documents are relevant to the case. Accordingly, the geographic limiters cannot be understood as even a rational attempt to target document collection to conduct that occurred in the U.S. He also rejected the defendant's argument that the plaintiffs were attempting to reopen settled search terms, noting that for at least 3 months, the plaintiffs had been objecting to the use of geographic limiters on searches, and he rejected other arguments such as volume and burden as well. So, Tom, are you surprised that the plaintiffs agreed to the geographical limiters in the first place? What would have been a better approach to limit emails geographically?
Well, I'm not surprised that they tried to do it. No, I think, as everyone kind of agreed, this wasn't the best possible way. Judge Hickson himself, somewhere in his opinion, said the most common way of doing this is by choosing custodians. So his work involves the U.S. market, but that's not necessarily the only way. But yeah, one would have been just like, let's get a list of people who work in the U.S. and start with them. Another might have been some sort of sampling of some of those custodians to see what you come up with and see if there was some word or phrase that was common that referred to the U.S. market. Oftentimes, an office name might be located in the signature line. You know, Tom O'Connor, New Orleans, Louisiana. You could have come up with a list of cities where the people, where the company had offices, and maybe tried that. And then maybe even a domain name. I just think that there's other ways you could have tried to do at it, but somebody, maybe it was you, Doug, are going to ask the question, doesn't this scream for some sort of tar? So I'll defer the answer to that and suggest that perhaps that would have been the answer.
Sure. Well, yeah. I have seen companies that are international enough to where their email addresses are different.
Yeah.
So sometimes that could be a potential. But yeah, absolutely. Custodian seems like the most common approach I've seen. And certainly, as you mentioned, Judge Hickson noted that as a common way of going about it. But since you provided a nice segue, I'll ask Judge Peck, because Judge Peck, I counted that there were 26 search strings referenced, and the example search string that was included in the ruling was enormous and had 56 terms in it. So is this a case that screams for the use of technology-assisted review?
It is. Indeed, I would say every big volume case is one where TAR should be used or at least considered. The question is whether one needs to do any pre-screening before putting the data into the TAR tool. And we just don't know enough about these companies and custodians and everything else. But I would certainly say, and if the problem was that these search strings without geographic limiters would require an additional 500,000 documents, doesn't mean that somebody has to read every one of those, put it into the TAR tool and, see what is relevant and what is flagged by the tool as not likely to be relevant.
Yeah, absolutely. And this one certainly seems like one that they should have absolutely considered TAR. But obviously a lot of parties do still go to the searching route. So Mary, what recommendations do you have for our audience to develop a better understanding of searching best practices?
Well, I think the first thing is to know what your index collects and organizes for you. For example, most eDiscovery indexes will exclude email signatures because they're generally not relevant, and they do that either textually or by size. They're usually a little picture.
Mm-hmm.
And so those things will be excluded. The other thing about searching is if you're going to make a representation about how effective this limitation is going to be for the other side, you should have some numbers behind that. And it looks like they just made a bald-face assertion without that later when things were produced didn't turn out. And so also what metadata can be searched. Can you combine things like IP addresses or domains, and then you might be able to exclude international content rather than include US material.
Mm-hmm.
But it's all about getting a representative sampling and testing and looking at your hit reports, but not just for one word, but for words in combination.
Yeah, absolutely. Well, and question from the audience ties to your point. Shouldn't courts expect parties to conduct sampling to help determine whether searches are properly scoped? This example is obvious, but there's a lot of cases where it isn't. I wish more of them did. Do any of y'all have any thoughts about that and about courts requiring the use of sampling?
I would say that often lawyers will look at hit counts and just say, oh, that search string returns 100,000 documents. It's too big. We have to cut it down.
Mm-hmm.
Question is, and that's where the sampling would come in, is it 100,000 documents because that was a really good search string and 99% of it is relevant? Or is it a terrible search string? There's too much just looking at numbers instead of the numbers in regard to content.
Right. Yeah, I couldn't agree more, and certainly would love to see some court rulings where sampling is a part of the discussion. So so some great points, and we will move on to our next case, which is Corker versus Costco Wholesale, and that's a dispute over whether the defendants were misrepresenting their coffee as Kona coffee. In it, the plaintiffs filed a motion to compel the defendants to produce information regarding defendants' purchases of, sales of, and profits from Kona-labeled coffee products prior to February 2015. The defendants objected, arguing that the parties previously agreed that discovery would be limited to the period after February 2015, the date on which the longest possible limitations period began to run, and the court had adopted that limitation. They also argued that the dramatic expansion of the relevant time period would cause prejudice, and that the requested production was not proportional to the needs of the case, unduly burdensome, and harassing. As noted explicitly in the ruling, the plaintiffs filed this motion to compel on the last possible day. Considering the plaintiff's motion, Washington District Judge Robert Lasnik stated, "The fact that a party is willing to make a concession to accede to a limitation during the meet and confer process does not forever bar it from pursuing the information if it is relevant and proportional to the needs of the case. The court therefore rejects defendants' argument that plaintiffs are barred from seeking information that might toll the statute of limitations and establish damages over a longer period. The court further finds that the requested information is relevant and proportional to the needs of the case." Sounds like the plaintiffs are looking good, right? Not so fast. Judge Lasnik also stated in denying the motion to compel, plaintiffs have known of their discovery rule, fraudulent concealment, and estoppel arguments for years, and yet they sought discovery dating back only to February 2015. Defendants have expended resources conducting searches, performing relevance reviews, and making productions based on the parameters plaintiffs set. These same activities would have to be repeated for a wholly different time frame if plaintiffs were permitted to expand the temporal scope of discovery from 4 years preceding the date of filing to the date on which each defendant began selling Kona-labeled coffee products. So when it comes to last-minute requested changes to discovery scope, it gets late early out there. So there you go, Judge Peck.
Oh, you promised. You promised.
No, that's not a shark. That's a Yogi Berraism. That's allowed. So, Judge Peck, considering that Judge Lasnik stated that the requested information is relevant and proportional to the needs of the case, are you surprised that he didn't grant the motion to compel, especially since it wasn't technically filed late?
I think I lost you there for a minute, but
okay. I can repeat the question. Are you surprised that Judge Lasnik didn't grant the motion to compel, especially since it wasn't technically filed late?
I mean, to me, it technically was late. Filing an extensive discovery motion the day before the discovery cutoff, even assuming there was no lag time and then how long it took for the motion to be fully briefed and gotten before the court, it's too late. So I agree with Judge Lasnik that it was late. And, he could have said, well, if plaintiff really wants this and is willing to have the trial date put off for a year to allow this to happen, plaintiff should want to go to trial fast. But, that is something that is in the court's discretion, whether to move the trial date or deny a late request for discovery. And it's sort of going back to our youth, the Goldilocks rule. The request for more discovery shouldn't be made too late, shouldn't be made too early, but when it's just right. And that's sometimes hard to do, but this one was clearly a too late.
All right. The Goldilocks rule. Very nice. Mary, we've all been in cases. We're often learning more information about evidence as a case unfolds. So what can parties do to identify sooner when they do need to request a change in scope of discovery?
Well, of course, the early evidence evaluation is a wonderful best practice where you take your claims and defenses and map against them, and then get some overall reports of your own data, and then of course the data that's produced to you. I'll just name 3 reports that are helpful in this area. One would be communication maps, so that you can find additional custodians. A timeline analysis so that you can see if there's gaps or if things are increasing at the beginning or end of your date range. And then alphabetical lists of people, places, and things so you can see and just, eyeball what's included and what's not included in your material. And then Maura Grossman, Dr. Grossman told us she always has a provision in her protocols, if she can get it, to get another bite of the apple if it's necessary. But here in this case, it looks like you wouldn't even need one.
Right. Yeah. Certainly notable as again, using the Goldilocks rule, that it was too late. So Tom, do you see the plaintiff's failure here as a legal strategy failure or project management failure, or is it both?
Well, I think it's both. I think certainly primarily or largely a legal strategy issue. Obviously, if you wait to the last possible day to file such a monstrous motion, and as Judge Peck pointed out, it's technically too late. Obviously, that's a legal strategy problem. But in this case, project management as well, because clearly, they'd agreed on the date parameters in the meet and confer, and as Judge Lasnik pointed out, they could change that. If they're finding information throughout the process that gives rise to extending that because there's information that's relevant outside of the date restrictions, and go ahead and move for it. And somebody should have been talking internally as the production came in and they're doing reviews to say, wait a minute, this isn't finding what we need. And it looks like there's information that goes back further than the date. They had ample time to go back in and, have another meet and confer, ask to have it changed. If the opponent said no, go back to the court and say, there's information that's, as the judge said, it's relevant, quote, relevant and proportional to the needs of the case. I'm seems certain that he would have been amenable to extending that. Instead, they waited until, the very last minute, when, again, as he pointed out, it would put an undue burden on the other side to try to do it. So I think it was a combination of both.
Yeah, that was my thought as well. Got a question from the audience. Why did the judge find this proportional if the judge also found undue burden and expense? And my thought would be, well, the judge found it proportional had the plaintiffs followed the Goldilocks rule and asked for it at the timing where the timing was right. But given the timing of it, found it was undue burden and expense at this point. Would you all agree?
Yeah, that was yeah. I'm sorry. Go ahead, Judge.
I was just going to say I agree with what Doug just said.
Yeah, what he said.
What he said. All right.
Same.
All right, very, very good. And just a reminder, we will be sending out a copy of the slide deck as well as a link to the on-demand copy of the webinar afterwards, so you can look for that. So those who are asking, there's your answer. All right, we'll move on to our next case. And that case is ripped from the headlines, at least the headlines of 2015. I'm sure many of you have seen the documentary Making a Murderer. I know my wife Paige and I binge watched it when it first came out. Not everyone depicted in this documentary appreciated how they were portrayed, including the plaintiff in this case, who filed a defamation case against Netflix and the documentarians. Netflix asked Respondent Michael Griesbach, who also happened to be one of the plaintiff's counsel of record, to produce documents related to his journalistic work, which concerned events about the case. He had authored 3 books about the case and was, by his own admission, obsessed with the case against Stephen Avery. But he objected to Netflix's subpoena on 5 grounds, including the evidence sought did not meet the federal rules of evidence 401 standard for admissibility, disclosure would prejudice plaintiff by turning his attorney into a witness, the respondent had no special knowledge concerning the evidence in the Avery case because he relied on public documents for his research, and that evidence was available from alternative sources. And most notably, Wisconsin's reporter privilege statute, you see a link to it right there, shielded the information sought from disclosure. Wisconsin District Judge Brett Ludwig began his order by stating, lawyers and journalists comprise, perhaps apocryphally, 2 of our country's most respected professions. Not sure if that's a compliment or not. Regardless, Judge Ludwig addressed the respondent's first objection, stating, this is a classic category error. What is discoverable is not always, and indeed does not need to be, admissible. The discovery provisions of the Federal Rules of Civil Procedure are to be applied as broadly and liberally as possible to allow parties to explore possible leads. He also rejected the respondent's 2nd, 3rd, and 4th objections, stating, there's nothing to see here is not a valid defense to a properly issued subpoena. Most notably, he rejected the respondent's objection regarding reporter privilege, citing an uncannily similar case, which found that a filmmaker who had joined the plaintiff's litigation team could not wield the reporter's privilege as both a sword and shield to benefit his client and disadvantage the opponent, and stated, respondent cannot allow Colborn to selectively access and thereby weaponize only the most advantageous facts, while his adversaries are denied that access and left grasping in the dark. This is precisely the kind of situation that the sword and shield waiver doctrine is meant to prevent. As a result, he found the statute is not applicable in the respondent's case. So, Mary, are you surprised a licensed attorney cited FRE 401's admissibility standard when this was a discovery issue? Or do you think he was just trying to find as many objections as possible, hoping one would stick?
I think you're right. Probably looking for all the objections. But, I wonder why you couldn't argue that it's disproportional to go after material that's not admissible. I think there might be an argument there, but This is an interesting one.
Mm-hmm. Oh yeah, absolutely, and certainly a person, I guess a third party in a unique position, if, for lack of a better way of looking at it. So, with that in mind, Tom, does it seem that being a journalist who's written 3 books about the case associated with the documentary is a conflict of interest with providing representation of one of the parties in a defamation case about the same documentary?
I don't think so. I'm not sure there's a conflict of interest there, unless in his material, his notes, and it was clear they were going after all of his information. There was something privileged that had been told him, or he wanted to protect a source of some sort. I didn't hear anything about anything remotely like that would tend to bring it up. So, but those privileges, I think, would be asserted by the individuals involved. So maybe a source by the publisher in him, if there was some sort of a confidential source that they didn't want to reveal, but it didn't seem like that had happened. So it seemed like more of a discussion, on that reporter privilege in the statute, which the judge went through extensively. And it basically, both sides have to have access. If he's allowed to look at everything, the other side has to look at it too. I'm surprised, though, Doug, I got to say that you passed up an opportunity to give a Star Wars joke there on the "Nothing to See Here" line by the judge.
Well,
like a lob softball there for you.
You guys told me to stop, so
so I like
never listened before.
Yeah. The judge's writing style is pretty humorous. However, someplace else in the opinion, he said something about one of the agreements had almost as much weight as a pinky promise.
Right.
So,
yeah. He had a few good lines in there. Obviously, his opening line was interesting to say the least. And he did, and I think one of the things he did note is that because those middle objections, especially no spatial knowledge, relying on public documents, he noted that they were asking for information that was clearly not public, and so that could have been including information from sources that I'm sure he would probably prefer not to disclose.
Yeah.
So yeah, absolutely. I think that's understandable. So Judge Peck, this may be a simple question, but if the respondent chose to quit the plaintiff's legal team, could he then justifiably exercise the reporter privilege from the Wisconsin statute? Or is it too late once he's been counsel of record?
Short answer to a simple question. Too late. He was already counsel of record, apparently for quite a while in the case. So, no. But I do want to mention one other point that Judge Ludwig made in the decision. And he pointed out that the subpoena recipient did not assert the reporter privilege in his initial response to the subpoena. And the judge found that wasn't a waiver. It's okay, but it does. Anytime a party comes up with what seems like a last-minute Hail Mary claim or something that wasn't raised at the first possible opportunity, it may not go over well with the court.
Yeah. Oh, that's I'd forgotten about that, and that's certainly a very good point. I guess one other thing I had wondered about, because I was kind of trying to decide which question to ask you. I thought it's a federal case, but it's obviously a Wisconsin statute that's cited here with regards to reporter privilege. Is that because there's no, I guess, federal kind of statute or federal law that deals with reporter privilege? Or
my memory is that there is not. So it's a state-by-state analysis.
Okay. Well, that's what I thought as well. So I had kind of wondered about that. So yeah, very interesting case, and it will be interesting to see how it proceeds. And we will move on to our next case. And this next case, honestly, is a bit confusing as to who did what to cause the issues here.
Mm-hmm.
So I'm going to try to kind of explain it, or at least recite it, if you will, and we'll go from there. So This case involved claims of misappropriation of trade secrets, and the parties brought 3 disputes before the court. We're covering one of them here, which was a request by the defendant to shift the cost of attorney's fees for redoing a production where source files that are attachment to emails were separated in a production by the defendant. So what happened? Well, the employee defendants produced documents in their possession to the plaintiff, which reviewed the documents and selected target files. The defendant then ran the files on its system with a hash value comparison and unique search strings, and the plaintiff was allowed to verify the searches at its own expense with its own vendor. That vendor ran search strings and hash value searches on the defendant's data to create a set of source files, which it then gave back to defendant's counsel, who reviewed the documents for privilege and then produced non-privileged responsive documents, including the files and metadata, to the plaintiff. A lot of back and forth here. The plaintiff identified over 2,000 source files that are attachments to emails that were separated and wanted the defendant to redo the production. The defendant contended it was the plaintiff's vendor that separated the source files, which were email attachments, from the parent emails when creating the production set of source files, stating the production of the parent emails could have been done earlier and cost effectively if the Zeiss vendor did not split up the family files. So the defendant resisted the plaintiff's demand that the defendant review the source files and parent emails and produce them unless the plaintiff paid for the additional discovery costs, which was about $40,000. California Magistrate Judge Laurel Beeler stated, TopCon was required under the ESI protocol to produce all metadata, including family files. There is no dispute that Zeiss is entitled to the source files, but on this record, it is not clear how Zeiss could have avoided the costs or whether the costs are duplicative. The court denies the request for fees without prejudice and orders TopCon to review and produce the files. So the defendant's cost-shifting request was rejected by Judge Beeler. Tom, do you think this issue could have been avoided with more active management of the vendors involved in this project?
I'm sorry, could you explain that one more time?
Yeah, I'm surprised I could explain. I could have recited the first time.
Hey, this goes back to, leaving aside the confusion, this goes back to something that we've talked about in several other cases over the year, which is the protocol agreement. All right. Mm-hmm. The judge pointed out at one point, well, they were entitled they're required under the ESI protocol to produce all the metadata. Well, don't agree to separate attachments from emails in the protocol or specify in the protocol that you won't do that. I'm involved in advising a client right now on that very point where the other side wanted to do it. And I said, no, if the document's attached to an email, I want it. Or I want some designation of the family structure. Sometimes I think, and this has become a rapid issue as rapidly growing issue as vendors are, we can do a whole family tree. We can show you all of this in one view or another view, or we can split it up. Sometimes vendors like to do things that are technically proficient because they can. And I think the attorneys need to step back and look at what it is they're attempting to do and what the results are of some of the productions they're talking about. If they had simply stated, asserted, agreed to whatever in the protocol that attachments would remain attached, hence their name, then this would have been avoided.
Yeah, absolutely. And I wonder, I don't know what the ESI protocol looks like in this particular case. I don't know if it's as convoluted as the process appeared to be, but certainly it seems like sometimes the ESI protocol can lock people in to when it comes to, I guess, considerations that they maybe haven't anticipated beforehand.
Right.
That's a great point that we're seeing more cases involving ESI protocols, which I think is a good thing. But yeah, absolutely does tend to lock them in. So Judge Peck, do you think that Judge Beeler's statement that it wasn't clear how the plaintiff could have avoided the costs and the fact that the request for fees was denied without prejudice left an opening for the defendant to refile with more information regarding who is responsible for the production issues?
Yeah, but probably would not work And of course, the question is this too much ado about nothing? I mean, 40,000 is the additional discovery cost. This sounds like the sort of case with mega firms and, $1,000 or more billing rates per hour. Was it really cost effective to have this fight? The other more substantive thought is that they said that the extra 40,000 was for privilege review of the parent emails and attachments. I'm missing something perhaps, and the judge was not overly clear in anything here. But if this was merely going from Goldilocks to Humpty Dumpty, putting Humpty Dumpty together again, presumably if they produced the parent and the attachment separately, having done a privilege review, I'm not sure why the matching up would require a further privilege review. So something is missing here. I think we've all figured that out. We just don't know what.
That's a great point. And I will unashamedly admit that sometimes I select cases because they're interesting and short, and sometimes maybe they're a little too short, and maybe they could have explained a part of it, or at least this particular part of it, a little bit more in detail. But that's a great point, Judge Peck. So Mary, since both parties were so actively involved in the production process, wouldn't it have been fair for them to split the cost to redo the production?
I think it's interesting because this is it's a trade secret case, and it says the plaintiff hired a vendor which ran search strings and hash value searches on the defendant's data to create a set of source files. So it would seem that the plaintiff, since they hired the vendor, would tell the vendor what settings to use, whether to include families or break up families. Or whatever. So I think this is a discovery about discovery and finding out what is Apac's default setting for parents and children on emails, and did the plaintiff change the default? I think there'd be some things in there, but yes, I think your question about wouldn't it have been fairer for them to split the cost? That would be probably fair. Yeah.
And again, goes back to Tom's comments about managing the vendors. Sometimes you can overly manage or mismanage or however you look at it. So yeah, absolutely, an interesting case and a very interesting process there. So we will move on to our next case. Which is really one that illustrates the battle between privacy and relevancy that we're seeing in many courts today. In this case, alleging unlicensed use of the plaintiff's software, the defendants, who were China-based, argued that China's relatively new personal information protection law, you see the link to the translated law there, and the law was enacted last November. They argued that it prohibited transfer of computers in China across international borders without consent of current and former employees who declined to agree. Previously, the court had ordered the defendants to deliver and produce for inspection 24 computers to the U.S. within 2 weeks, rejecting the defendants' objections based on Chinese data privacy law because they hadn't identified any particular provision of Chinese law prohibiting production, and therefore waived any such argument. So the defendants filed a motion for reconsideration, and decided to get specific, arguing that Article 39 of the PIPL requires consent from an individual before that individual's personal information may be transferred outside of China, and ordering them to produce the computers would violate Chinese law. But the plaintiff contended that the defendants waived the objection based on the PIPL by failing to raise that argument with any specificity before the motion for reconsideration, and also noted that the PIPL was not yet effective when the plaintiff first requested inspection of these computers. The plaintiff also contended that the PIPL includes an applicable exemption for compliance with a legal obligation, which is Clause 3 in Article 13 of the PIPL. California Magistrate Judge Joseph Sparrow began his analysis by finding that the defendants had not satisfied Local Rule 79B regarding requirements for a motion for leave to file a motion for reconsideration. That would be enough to deny the motion right there, but Judge Sparrow proceeded to analyze whether the PIPL doesn't prohibit production of the computers. Finding that the interpretation of the provisions by the plaintiff's expert to be more persuasive than that of the defendant's expert, he stated, the court holds that the exceptions in Article 13 apply to the consent requirement of Article 39. As for whether the exceptions were limited to Chinese law, Judge Sparrow stated nothing in the PIPL itself indicates that the exception is limited to Chinese law. So he denied the motion for reconsideration on several grounds. The question now is, will that matter? So Judge Peck, are personal privacy rights ever likely to keep information determined to be relevant from being produced in U.S. litigation? In other words, does relevancy almost always supersede privacy protection, or does it depend on the privacy law and how relevant the information is?
First, again, a procedural point for the audience. If you're going to make an argument based on foreign privacy law or anything else, present your information about that at the time you're first arguing the motion. The standard for a motion to reconsider is quite different. It's not a, let me see if I could win without doing a lot of work. Oops, I lost. Let's move for reconsideration and put additional evidence in front of the judge. I would say that almost as long as I've been practicing, for purely domestic privacy considerations, the answer is usually the standard protective order. And almost never does the fact that it's private information prevent discovery when it's relevant. It's different when the courts are trying to give comity, that's C-O-M-I-T-Y, not comedy, E-D-Y, to foreign law. We've mostly seen it over the years with the GDPR and its predecessor, where the court is required to do an aerospatial analysis after the Supreme Court decision. And even there, in 95% of the cases doing the aerospatial analysis, under the balancing fifth step of what's more important, U.S. interests or the foreign interests, courts tend to find that U.S. discovery important to the rule of law and just decision of cases is more important than foreign privacy law. Nevertheless, it does put a company between a rock and a hard place. You produce the material for discovery so as not to get in trouble with the U.S. court and thereby violate the GDPR or the PIPL where it's applicable, or do you tell the U.S. court, sorry, I got to listen to my home jurisdiction and I can't do it, and wind up with sanctions in the U.S. court? It is not easy in practice to deal with it.
That's for sure. And I think we're just going to continue to see more of it as we have so many international privacy laws that have been enacted in recent years. So speaking of which, Mary, EDRM recently published an Apac primer for eDiscovery, which of course includes China, and it also includes data privacy laws for Apac countries as well. So what recommendations do you have for our audience when it comes to managing discovery and data privacy laws in different countries? Are you there, Mary?
Ooh, I am indeed.
Okay, cool.
Thanks. So
Okay. How about I come back to Mary, because it looks like she's kind of clicked off here for a moment. It
Oh,
happened. Oh
so
no!
sorry, but all right. I'll just add one last thing is you can't necessarily rest on a let's see what the regulators do. Let's wait till something comes out that has some teeth, because China just fined Didi, which is an Uber-like company, $1.2 billion for a whole laundry list of privacy violations. So they're quite active, and their fines are rather large. And I don't know what's happening with my mute button, but I'll try to attend here.
All right. Well, I know that was the part we missed was an absolutely terrific answer. So that there's no doubt, and great point. I mean, China, if anybody treats security and privacy seriously, it's China, and they're in a couple of different aspects to it, if you want to look at it that way. So one of the things that I'm thinking about, Tom, when it comes to this decision is, okay, great. China defendants have been ordered to produce these computers, but what do you think the odds are they actually will do so? And if they don't, what recourse does the plaintiff have?
The odds that they'll actually do so, I think, are fast approaching zero. Look, I understand Judge Peck's discussion of comedy, and our interest in honoring other countries' statutes. But in this case, we've got an American judge interpreting what the foreign statute means, and then ordering the Chinese citizens to comply with an order of a court here, so they can face sanctions from a U.S. court or potential sanctions from a Chinese court. And I'm not sure the Chinese citizens want to face the latter. And I just think it would be unlikely that they do so. And I also thought, and you asked what recourse, it wasn't there something in there that said that there was an option to investigate the computers in place. In other words, go to China and examine them there. As far as China and personal information protection, I am mindful of several times I worked with our old friend Browning Marian on cases over there. The fact that when they sent people over to do business from their office in China, they would always give them brand new, fresh computers and cell phones that had nothing from the home office on them, and instruct them not to dial in to the home office from their hotel in China. And when they came home with those computers, they threw them away. I'm not sure that personal information protection inside China for Chinese citizens means the same thing that it does for non-Chinese citizens. And I'm skeptical, to say the least.
Hey,
Sure.
Tom, I thought you were going to go with Browning's line, which, of course, our HR department hated him saying, which is, sure, if we were going to a foreign country to do, some computer forensics or whatever, we would send a young associate. So if they got arrested and kept in jail for a while, it wouldn't be as bad as if I were arrested.
That I do remember that now that you brought it up. That yes, senior people from your firm rarely made trips to China, and Browning loved to travel. So that was also telling. Yeah, good point.
Yeah, absolutely. Question here from the audience related to cross-border discovery. Germany recently changed local laws with regard to the process of requesting document production via the Hague Convention on the taking of evidence abroad. Some of the requirements Germany included in the new law are similar to the Aerospatiale test. Judge Peck, have you seen this change in German law? And do you think federal courts in the U.S. will be more willing to go the route via the Hague Convention after this new law was enacted?
I have not seen it. Of course, most, like we have states, Germany has state equivalents or whatever, and the data protection authorities of one such state may have very different rules than others. So it may not be universal for Germany. It also comes down to how quickly will there be a response to such a Hague Convention. requests. That has always been one of the concerns in U.S. courts, that sending a Hague Convention request could take months or years to get a response.
Yeah, that's definitely interesting, and it's an ever-changing kind of area, and kind of an ever-changing scenario. So I'm sure we will see more cases like these in the future. We're going to move on to our last case, and of course, Tom and Judge Peck are great at suggesting cases for us to cover each month, but I think this is the first time that they both suggested the same case. There we go. So, and it's also unique in that it's a criminal case and a state case to boot. In this New Mexico state criminal case, a 17-year-old child and her 19-year-old friend, Jeremiah Erickson, got together one night and literally had a he said, she said about what happened. Erickson claimed that the child appeared to be high or drunk and jumped into his car when he exited, crashing through a chain link fence, striking a dumpster, and driving the car out of his sight. Child claimed Erickson was drunk and that she exited the car after he made advances toward her and ultimately walked home. She also claimed she didn't have her phone with her after leaving Erickson's vehicle. But Facebook Messenger messages told a different story, at least in the form of screenshots produced by the state, as you can see here on the slide, where the child defendant said multiple times that she was drunk and seemed to admit that she took the car. The state sought authentication of the social media evidence through Erickson's testimony as to his personal knowledge of both the accuracy of the screenshots and his history of Facebook Messenger communications with child, as well as through the contents of the messages themselves. And the evidence was admitted over the objection of child's trial counsel. However, the Court of Appeals reversed based solely on the authentication of the social media evidence issue, finding that the state had failed in its burden to properly authenticate the messages and found that the content of the messages was not sufficiently confidential to establish that only child could have authored the messages. On appeal, the Supreme Court of New Mexico found that the state's authentication showing was sufficient under New Mexico Rule 11901 to support a finding that more likely than not, the Facebook Messenger account used to send the messages belonged to child and that child was the author of the messages. So the Supreme Court reversed the Court of Appeals and reinstated the child's delinquency adjudications. So, Mary, do you think we're seeing so many more authentication cases these days because we have so many more forms of ESI and discovery than we used to?
Oh, absolutely, Doug. That, and in criminal cases, you're going to see, more activity around authentication as well. And all these new forms, they're easier and easier ways for people to communicate. And you feel like nobody's looking, but you take a look at what's on the screen here, and that's quite a conversation. They're all designed to be easy to use and addictive, casual, and not necessarily to have a complete chain of custody when somebody downloads it or, screenshots it and things like that. So, yes, I do think we're seeing more and more on authentication. Yeah,
certainly seems like that. I think Tom said these cases are falling from the sky, and I agree. So speaking of screenshots, so Tom, even though there was testimony from Erickson and other evidence, do you think a screenshot is sufficient for authentication of evidence, given how easy it is to manipulate them?
No. It was for a long time. It was the most common method of authentication, but we've clearly been moving away from that. But also there's a distinction here, I think. But for many years, screenshots, and by many years I mean like 10 years ago, the infancy days of forensic authentication of social media, especially in criminal cases. It was a question of how did you show it, and was a screenshot the way to do it? The Maryland case, you had the Maryland standard versus the Texas standard. The Maryland case of Griffin versus the state. It's a 2011 Maryland Court of Appeals case involving Antoine Boozy Griffin, not to be confused with Terrence Little Boozy Hatch of Baton Rouge, who had a series of other cases which had nothing to do with social media. But that the Boozy Griffin case involved his girlfriend's website, which had the famous "Snitches Get Stitches" line. He had been convicted of murder and was accused of intimidating a witness. And they simply used a police officer to testify. I went to the girlfriend's site. I called it up. These are screenshots of what I saw, to which she and her attorney demurred, yeah, but he didn't prove that was me. Anybody could have used my name. There's no authentication. So now, we've got better ways of doing that. But also in this case, you had a Facebook Messenger communication between two people, and you're using one of those two people to authenticate what they're seeing on the screenshots. Mm-hmm. So I think that's a little bit different, as the Supreme Court of the state indicated. Is there a likelihood that, more likely than not, that this is valid authentication when you're using one of the two people in the communication to authenticate what it was? I think that's a different standard.
Sure. And of course, you mentioned Maryland is another state. This is obviously a New Mexico state case. So, Judge Peck, do you think this level of authentication and the standard of it's more likely than not to be authentic would have held up in federal court?
I think so. Certainly it would have in a civil case. I never did much in the way of criminal law practice, so I can't say for sure. And again, it might have been different if this were a case where Erickson was suing the female for, the damage to his car. Would his self-serving authentication of the documents be enough? Maybe, probably. Alternatively, we discussed a case several one of these webinars ago where the picture or screenshot supposedly of a message on a text used emojis that would not have existed at that time.
Right.
So if there is evidence that, something is rotten in the state of New Mexico, that maybe the standard would be different. I do want to, we're talking about this from the judge's or court decision point of view. I am a little troubled that the case says that the girl claimed that she left her phone in the car with Erickson or in Erickson's vehicle.
Right.
Query whether that was argued at trial that maybe it wouldn't have been easy to fake this message, but if Erickson had her phone, he could have sent messages to himself, pretending to be her and responded and et cetera, et cetera. I mean, that I thought was perhaps the most interesting fact in all of this.
Yeah. Right. Or at least her statement, which, may or may not have been truthful, but certainly an interesting and valid point. A question from the audience: why wouldn't the state have introduced the messages in native form from Erickson's Facebook Messenger account instead of through screenshots? It seems as though there would have been no basis for appeal if they did that. Thoughts about that? I mean, the form of how it's produced. Do you think that matters here?
I think it matters, but the prosecutors may not have had the ability to get to the original messages in a digitally sound way. Maybe Erickson took the screenshot right away because his car was wrecked and he wasn't sure what was going to happen, but the Facebook Messenger messages disappeared. I don't know enough about Facebook Messenger to know what the retention would be and whether the state prosecutors could have gotten it from Facebook or not. So there are a lot of questions, but certainly if they did it forensically, it would have been one less issue for there to be an appeal on.
Yeah, I think the judge is absolutely correct, though. From the prosecutor's perspective, quicker and easier to just take the testimony, which they had no reason to believe wouldn't be accepted. And certainly my experience in working in the criminal arena is that police agency, whether it's at the state or the federal level, forensics labs are horrendously backed up. So we just don't know how easy and how quickly the prosecutors there could have done a forensics examination of the phone and been able to get it to the prosecutors.
Sure. Yeah, I mean, I can speak. I reluctantly use Facebook Messenger because I'm on Facebook and people message me. And and as far as I know, by default there's no real the retention is forever unless you change it. So certainly the messages would be there. But we are at the top of the hour, and I hopefully made it through all the way this time as we get to the contacts page. And we do have a date for our next case law webinar, which is on Tuesday, August 30th. If you didn't get a chance to register via the link here, certainly go to the EDRM site and do so. I wish I had a pun for the fact that it's on August 30th, but I don't. Except to say that to tell you all to enjoy the rest of your Shark Week / eDiscovery Case Week. And I'll turn it back over to you, Mary.
Thanks, Doug. EDRM would like to thank you, Doug, for anchoring, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention. Tune in next month for our Case Law for August on the EDRM Global Webinar channel. Thank you.